That is the gospel of U.S. immigration planning. Wait, be patient. File when you are ready, when your finances are in order, when your family situation is more stable, when the timing finally feels right. And for an enormous number of immigrants living and working legally in the United States right now, people who have been here for 15, 20, sometimes 30 years, that gospel is mathematically, strategically, and in some cases permanently and catastrophically wrong. In this video, I am going to walk you through 7 specific situations where filing for a green card at age 62 is not a mistake. It is not impatience. It is not jumping the gun. It is the single smartest immigration and financial move a long-term visa holder can make. And I want to be upfront about something before we start because I think it matters. Most of the immigration content you find on YouTube is made by attorneys. And I am not saying attorneys are bad people. I work alongside immigration attorneys every single week, and some of them are absolutely excellent. But attorneys get paid by the filing, by the retainer, by the complexity of the case. They have a structural incentive to tell you that timing doesn't really matter, that you should let the process unfold, that there is no rush. I am going to tell you something different today. And the reason I can tell you something different is because I am not an immigration attorney. I am an enrolled agent, federally licensed to represent taxpayers before the Internal Revenue Service. And I work every week with aging immigrants, long-term visa holders, and people approaching retirement age on the intersection of immigration status and retirement financial planning. What I see in my practice every week is the exact opposite of what you are being told on the immigration side of YouTube. The immigrants who wait too long to file, who delay past 62 in the wrong situation, pay tens of thousands of dollars in unnecessary legal fees, lose access to federal benefit programs they have been paying into for decades, get hit with Medicare eligibility gaps that nobody warned them about, and in the worst cases, leave their surviving spouse in an immigration and financial situation that no amount of money can fully repair. The immigrants who file at 62 in the right situation lock in a legal status that protects their retirement income, unlocks federal benefit access, and builds a foundation for the rest of their life in this country that no temporary visa, not an H-1B, not an L-1, not an O-1, nothing can replicate. So here's what we are going to cover today. Reason number 1 is going to surprise you because almost no immigration professional will ever bring it up in a YouTube video. Reason number 2 is the situation that is catching thousands of immigrants right now who came here on employment visas and are staring at a mandatory departure problem in their early 60s that they did not see coming. Reason number 3 is the family history reason. I mean, this one is personal because if your parents or grandparents did not live long lives, this math changes everything. Reason number 4 is for married couples where one spouse is a citizen and the other is still on a visa. And the survivor benefit math here is something almost nobody talks about. Reason number 5 is for immigrants with minor or disabled children still at home who do not realize that their immigration status is directly shaping what their children can and cannot access. Reason number 6 is for divorced immigrants. I mean, I want to be careful here because this is a sensitive situation. But almost half of you watching this are going to qualify for something you have never been told about. And reason number 7 is the reason every immigrant under 65 needs to take seriously right now, because what is happening inside USCIS in 2025 and 2026 is not a temporary backlog problem. It is a structural shift that is going to make filing for permanent residency significantly harder and more expensive every single year you wait. My name is Marcus Graves. I am an enrolled agent, and I have been working with immigrant families on tax and retirement financial planning for going on 14 years now. And before I get into the 7 reasons, I need to tell you about a couple I worked with because their story is, it still bothers me when I think about it, because the mistake they made was so avoidable, and it cost them in a way that cannot be undone. Amir and Fatima. They came to the United States from Iran in 1991. Amir spent 31 years working as a civil engineer for a private infrastructure company in Texas. Fatima raised their 3 children, worked part-time for about 14 of those years as a medical interpreter for a hospital system in Houston. Amir came in on an H-1B, converted to an EB-2 green card in 2003. Fatima was added as a derivative beneficiary. They are both naturalized citizens today. So the story ends okay. But the period between Amir's 61st birthday and his 65th birthday is the part I need you to understand, because it is being replicated right now across this country by hundreds of thousands of immigrants who are making the exact same mistake Amir made when his immigration attorney told him, and I am paraphrasing here, but this is pretty close to word for word what he told me. The attorney said, "There's no rush. Your status is fine. We can handle this whenever you're ready." And Amir believed him. Why wouldn't he? The guy was the expert. What the attorney did not model out, because attorneys generally are not thinking about the retirement financial picture the way I am, was what happened to Amir's Social Security access, his Medicare coordination, his Roth conversion window, and Fatima's survivor benefit situation when Amir had a cardiac event at 63 and could not work anymore. His Medicare Part A was intact. He had the quarters. But the coordination between his status documentation, his Social Security disability claim, and the supplemental state programs that would have covered the gap was a mess that took 18 months to sort out. 18 months where Fatima was doing everything right and still getting the wrong answer from every agency she called. And some of those months of benefit access, they are simply gone. You cannot go back and collect them. That is the cost of the wait and see approach when the thing you are waiting for does not happen on schedule. So with Amir and Fatima in mind, let me walk you through the 7 reasons. Reason number 1 is the Social Security quarters clock, and this is the foundational financial reason that every aging immigrant needs to understand before they make any decision about when to file for immigration status. Social Security retirement benefits in the United States require a minimum of 40 quarters of covered employment. That is 10 years of working and paying FICA taxes. Most immigrants who came here in their 30s or 40s on work visas hit that number. But, and this is the part that gets missed, Social Security will pay full unrestricted retirement benefits only to individuals who are U.S. citizens or lawful permanent residents at the time they claim. If you are still on a temporary visa when you stop working, your Social Security contributions do not disappear exactly, but your ability to access them becomes subject to a legal framework that is genuinely complicated. There are tax treaties involved. There are residency requirements. There are situations where benefits get suspended if you leave the country for an extended period. All of that complexity goes away the moment you have permanent residency. Filing for your green card or completing naturalization before you stop working at 62 ensures that your Social Security benefit is clean, accessible, and fully coordinated with your tax situation from day one. And the reason this matters so much on the tax side is this: the window between when you retire and when your required minimum distributions begin at 73 is the lowest tax period of your entire retirement. If your Social Security access is delayed or complicated by a status gap, you lose that conversion runway. You lose the ability to move money from your traditional IRA into a Roth at the 12% bracket before RMDs force everything into a higher tax rate. That opportunity does not come back. Once the window closes, it closes. Reason number 2 is what I call the mandatory departure trap, and this one is urgent right now because of where we are in the EB backlog cycle. The employment-based visas, the H-1B, the L-1, the O-1, are non-immigrant visas. They are tied to your employment. The moment your employment ends, your authorized period of stay ends. For a 61-year-old engineer or IT professional or healthcare worker who has spent 18, 20, sometimes 25 years on H-1B extensions and is starting to think about retirement, the immigration math is brutal and very few people are doing it. Your visa expires when your job ends. If you have not filed for a green card before that date, or if your green card application is not far enough along in the process to give you protected status under AC-21 portability, you are looking at a situation where you either have to find new sponsoring employment in your early 60s, which, look, let's be honest about what the job market looks like for a 62-year-old in most industries, or you leave the country, or you fall out of status. And falling out of status after 20 years of lawful presence in the United States is not just a legal problem, it is a financial catastrophe. It can affect your Social Security access. It can create bars to reentry. It can put your spouse's status at risk. Filing for permanent residency before 62 while your employment sponsorship is still active and your priority date is current is the only clean way to retire in this country legally if you came in on an employment visa. And I want to say something here that I think needs to be said plainly. The EB2 and EB3 India and China priority dates have been moving in a way that is giving a lot of people hope right now. If your date is current or close to current and you are approaching 62, this is not a situation where you sit back and feel good about the progress. This is the moment you file. This is the window. Reason number 3 is the longevity math. And this one is personal in a way that the other reasons are not, because it requires you to look at your family honestly. Green card and citizenship applications take time. USCIS processing times for Form I-485 adjustment of status are currently running between 14 months on the low end and 36 months on the high end, depending on your field office and your visa category. Naturalization applications are running 12 to 24 months in most places. If you are 62 today and you decide to wait another year to begin your application, maybe because work is busy, maybe because you are not sure you want to stay permanently, maybe because your attorney told you there is no rush, you are looking at a realistic completion date somewhere between 64 and 66. Now look at your family. Actually look. What happened to the men in your family? Your father, your grandfather, your uncles. If the men in your family are not living past their mid-70s, and many families have this pattern, then waiting until 64 or 65 to begin a process that takes 2 or 3 years means you are filing your I-485 at an age where a serious health event becomes statistically more likely before the case is approved. And if you become incapacitated during the process, if you die before approval, the cascading consequences for your spouse and your children are the kind of thing I'm not going to sugarcoat. Your spouse's immigration status becomes uncertain. Your children's derivative status becomes uncertain. Your surviving spouse's ability to collect Social Security survivor benefits on your record, which for a high-earning immigrant can be worth hundreds of thousands of dollars over a lifetime, gets complicated in ways that should never have been allowed to get complicated. The actuarial tables are not abstract. They are about your family specifically. Run the math on your family before you decide to wait. Reason number 4 is the surviving spouse protection gap. And this is the reason that married couples in mixed status households, where one spouse is a citizen and the other is still on a visa, need to take most seriously. Social Security survivor benefits are among the most powerful financial protections in the American retirement system. When one spouse dies, the surviving spouse can collect the deceased spouse's Social Security benefit if it is larger than their own. For a couple where one spouse earns significantly more, this survivor benefit is often the single largest income source the surviving spouse will have for the rest of their life. But a surviving non-citizen spouse faces a different set of rules. The complexity around tax treaties, the risk of benefit suspension during extended international travel, the documentation requirements, all of it creates friction and uncertainty that should not exist for someone who has been here for 25 years and whose spouse paid into the Social Security system for 3 decades. Filing for a green card before you retire eliminates that friction entirely. Your surviving spouse collects what they are owed cleanly, without lawyers, without appeals, without uncertainty. And I want to be honest, I have seen what happens when this is not in place. I have sat across from widows who came into my office 6 months after losing their husband, still on a dependent visa, trying to understand why the Social Security office was giving them confusing answers about their survivor benefit claim. That is not a conversation anyone should have to have. Filing before 62 prevents it. Reason number 5 is the dependent access problem, and this is one that catches immigrants who had children later in life or who are raising grandchildren or who have a disabled adult child at home. When a non-citizen parent retires in the United States, the children's access to federal student financial aid, state-funded health care programs, and in-state tuition at public universities can be directly affected by the parent's immigration status, depending on which state you are in. A child whose parent is a permanent resident or citizen is on solid legal and financial footing. A child whose parent is still on a temporary employment visa when that parent retires occupies a gray area that I see create real problems for families, particularly in states with strict immigration-based eligibility requirements for education benefits. For any immigrant approaching 62 who has minor children, college-age children, or a disabled child who relies on government support, the parent's immigration status is not just about the parent. It is about the foundation the entire household stands on. Every year of delay is a year of unnecessary vulnerability that your children are absorbing on your behalf. Reason number 6 is the divorced immigrant situation, and I want to be careful and gentle here because I know this is a sensitive area, but I also know that not saying it clearly is worse. If you came to the United States on a spousal visa to CR1, an IR1, a K1, and your marriage ended in divorce before you obtained your full 10-year permanent residence card, you may still have a path to removing conditions on your residence through a waiver petition that does not require your ex-spouse's participation or cooperation. More importantly, if your marriage to a U.S. citizen lasted at least 10 years before the divorce, you may be entitled to a Social Security divorce spouse benefit based on your ex-spouse's earnings record, exactly as I would describe for any divorced American, and you can claim it at 62 without their knowledge or cooperation. The Social Security Administration will pay it if you qualify. I work with divorced immigrants who spent 15 or 20 years in this country, raised children here, built careers here, and who have a Social Security benefit available to them right now that they have never claimed because nobody told them it existed. If this is your situation, please call the Social Security Administration. Ask specifically about the divorced spouse benefit and speak to an immigration attorney about your pathway to removing conditions or completing naturalization independently. You have options that nobody has put in front of you yet. Reason number 7, and this is the one I want you to carry with you after you close this video, is the structural shift that is happening inside USCs right now that is going to make everything harder, slower, and more expensive every single year you wait. The public charge rule changes that have been rolling through the court system since 2019 have fundamentally changed the financial documentation burden for green card applicants. The income thresholds on Form I-864 Affidavit of Support have been increasing. USCIS filing fees have gone up substantially. And the processing backlogs, which are already running 14 to 36 months, are showing no meaningful sign of improvement under current funding levels. The political environment around immigration enforcement is not making this easier. If anything, it is adding layers of scrutiny and documentation requirements that were not there 5 years ago. What this means in practical terms is simple. The window in which your health is good, your employment is stable, your sponsor's income qualifies, your priority date is current, and the system is actually processing applications in a reasonable time frame is not permanent. It is a window. For immigrants approaching 62, that window is the one you are in right now. Filing is not jumping the gun. Filing is recognizing that the conditions for a successful application are not guaranteed to get better and are quite likely to get worse. Now, before I close, I need to talk about the trap, the one that catches the immigrants who follow the conventional wait and see advice without understanding the full cost of waiting. I call it the status cliff, and it is the single most avoidable and most expensive immigration mistake aging immigrants make. Here's how it happens. You have been in the United States for 22 years. You have been telling yourself you will handle the green card when things settle down and when the kids finish school, when the workload eases, when the timing feels right. Then you turn 62, your employer begins the retirement conversation, your H-1B renewal becomes uncertain, and you realize all at once that you are standing at the edge of a cliff. No permanent status, no clear Social Security claiming strategy, no Medicare eligibility certainty, no plan. And some of the options that were available to you at 58 or 59, the portability protections, the priority date advantages, the sponsor income situation, are no longer available because the circumstances changed while you were waiting for the timing to feel right. The immigrants who fall off this cliff are not the ones who filed at 62. They are the ones who followed generic advice without ever doing the math on what waiting actually costs them. Filing for your green card at 62 in the right situation is not impatience. It is not jumping ahead of yourself. For the 7 situations I walked through today, it is the single smartest legal and financial move you can make. The immigrants who lose the most in retirement are not the ones who filed early. They are the ones who delegated this decision to someone who was not looking at the full picture. If this video gave you something that the immigration YouTube world has never given you, please hit the like button right now. It takes 2 seconds and it genuinely changes how many people this reaches. Subscribe if you have not already, because next week I am releasing a follow-up video on the 3 exact steps every aging immigrant needs to take in the 12 months before they stop working, regardless of whether they file at 62 or later. And if you know someone, a coworker, a neighbor, a family member who is between 58 and 65, still on a work visa, still waiting on a priority date, still telling themselves the timing is not right yet, send this video to them directly. This decision is too large and too permanent to make based on a single attorney opinion or a single YouTube video. The 7 reasons need to be on the table. I will see you in the next one.